So what we're doing is pivoting in the course right now from dealing with, first of all, the virus and being at home and setting up with a new kind of software and so forth, over to now dealing with the text. If you recall, we have a text, Tyler's book, and I have various PowerPoints set up. My original intent was to flip the learning paradigm and have you guys teach us about each chapter with your own insights. This particular format doesn't work too well. So what I'm going to do is use those former students, PowerPoints, and then accent those things that I feel like you really need to know, building on, what will be on the final exam in terms of these take-home things. So what we're doing is trying to get into it here a little bit. Okay. What we'll do is just deal with one chapter today, the legal basis for preservation, and then designation of historic properties. We'll deal with that on Wednesday. So it shouldn't take too awful long, but I'm just trying to get all this stuff sorted out. So I'm going to begin by sharing a screen. Let's see where it is. Yes. Guess I don't have it up yet. Sorry. What I did. So I'll share this screen for now. And let's see, going to, sorry, here we go. I think that's there. Yep, there it is. Can everybody see this screen, the legal basis for preservation?
Yep.
Very good. I want to minimize everybody's face. I hate looking at myself while I'm trying to talk. You know what I mean? It's very distracting. Anyway, the legal basis for preservation. Now, how dry can this be, right? How many people here are future lawyers? I don't know, maybe one or two of you, but probably not everybody. But there's some basic ideas here which I think are worthwhile and concern everybody. As we start thinking about this, really what Tyler did was through the main philosophical ideas in the very beginning of the chapter, where he talks about the kind of nuances between various cases and how they kind of relate to each other. Basically looking, on the one hand, I'm looking at the text right now, the Fifth Amendment, which establishes the principle that private property should not be taken for public purpose without just compensation. The state can't come in and take your property without paying you for it. So that's basically the Fifth Amendment. It's all about private property rights. In South Carolina, we have Lucas versus the Coastal Conservation League, which after Hugo established that preeminence, again, in South Carolina especially. But then there's also the 14th Amendment, which calls for due process and equal protection, which means that basically it has to, if they take your property, it has to be for a legitimate, fair, reasonable use and must have a legitimate public purpose. So the Fifth and the 14th Amendment are what basically weighs in the whole balance sheet whenever we talk about historic properties or trying to deal with private property where maybe it's developing a nuisance or somehow detracting from the whole. This is kind of what government's about, trying to figure out how to deal with that. So here we are, that's the basic idea. Zoning, for example, is based on the idea that you can't put your butcher shop or a large-scale industrial concern right next to a neighborhood where people are trying to live, or a school or whatever, obviously creating pollution and problem. But it's always a question of interpretation, and there are sort of local influences always at work. The one case that came up that seemed to really start the whole discussion was one called Berman versus Parker, which in 1954 established that essentially a community should be beautiful as well as healthy, spacious, and clean. In other words, that aesthetics is an idea that somehow we can legislate for. The idea that somehow we can desire to have a beautiful place and make that part of the ruling law. What we have is referred to as the aesthetics plus principle, which allows for the local city or regulatory body to basically help with the aesthetics, and in our case, the historic character of a building. Notice there are three words there, which are kind of pivotal here: health, safety, and welfare. Those are the key words that or get dealt with whenever we start talking about the responsibilities of government. The 5th and the 14th Amendment, and also health, safety, and welfare, and the right or the need of, and the overriding concern that local municipalities have to basically protect that. That is what they're there for. We all need that. We need police, we need fire, we need all that stuff, and it gets translated in various ways. So what we have here is the first Berman versus Parker case, which basically said that local municipalities could legislate for beautiful places, up to a point, of course. The next one here, if I'm saying it right, is Figarski versus Historic District Commission. I never knew how to say that. One day I'll figure it out. Well, essentially what we're dealing with is a structure that was part of a historic area, and the guy had no use for it, and he wanted to tear it down. But if you were to tear it down, then the whole sort of setting where it was all around a particular green would have been disturbed, and it would have opened up the views to some areas which were totally new and inappropriate, so forth. And so they basically said, you can't demolish it because it's important, even though it's only, a minor part of this area, its destruction could lead to a much worse consequence for the entire district or entire area. One of the other things too about the court case is it established the right of the court to go in and actually look at your books. And then just because you say you can't afford to take care of it doesn't mean it's so. And so as a property owner, you can take care of it or sell it, but you don't necessarily have the right to demolish it. Which is, I think, an interesting thing, especially in a place like Charleston. You can see how that builds the case for vernacular architecture. We have lots of Charleston single houses, and not particularly noteworthy, but taken as a whole, they add to the character of the entire district. And so you can see how this particular case helped to build that model that we use even here in Charleston. Now, the one case here, there's a few of them we're going through, and then we're going to talk in general, that really addressed historic preservation was the Penn Central decision. Essentially, Penn Central Station, train station coming into New York, was beautiful, classically styled building. The ownership of this particular group, the Penn Central Transportation Company, had to check that, in 1978, decided they wanted more money on the property than this particular place would allow. And so they suggested building a 55-story building on top of it. As you can see in the image here, that's one of several. There's another one in your text. Pretty amazing kind of idea. And basically, was all about trying to use your property to the maximum extent possible. Now, I should back up a minute and say that you should realize in New York City, it's different from Charleston. They don't have a historic district per se. They have a Landmarks Preservation Commission, an ordinance which basically highlights certain buildings as being really important to the character of the city. Rockefeller Square, or the Empire State Building. In this particular case, Penn Central, beautiful building, first impression of the city, become an icon for the entire city. And so they deal with their history differently from us. So this building was considered iconic, was one of the landmarks, and they opposed the building of this building because it would take this 55-story addition, because it would take over the entire property. It would make the whole thing seem rather silly if you look at it just on the face of it. But what ended up being done here, sort of following on the way that the Supreme Court and the courts took up the matter earlier, is they really got involved in the whole picture of it. And they looked at this particular group of folks, the Penn Central Transportation Company, and said, really seriously, you've got lots of properties. We can take your right to develop here 55 extra stories and provide that in other properties that are not going to affect historic buildings, so you can get your return on the property, and you'll be the same. So in other words, they're really looking at the books and seeing whether or not this is truly a hardship case. It's interesting to read, and you can see it in the text, the decision, it was the New York Court of Appeals, I'm sorry, not the Supreme Court, said the same use of the terminal was permitted as before. In other words, they're not taking anything away from you. It's not takings. The appellants had not shown that they could not earn a reasonable return on the investment in the terminal itself. So in other words, they were making money, they just weren't making as much money as they wanted to make. Even if the terminal operator could never operate a reasonable profit, some of the income from Penn Central's extensive real estate holdings in the area must be realistically imputed towards this structure. In other words, they're looking at the whole balance sheet. And then lastly, as we were just talking about, the development rights above the terminal, which were made transferable to numerous sites in the vicinity, provided significant compensation for the loss of rights above the terminal itself. So in other words, they looked at the balance of it and said, seriously, you don't really have to build that here, and it's an important landmark building, therefore we're going to say no to this. But it paved the way for this kind of a process, which actually is known in urban planning as transfer of development rights, or TDR. He doesn't mention that in the text, but that's what it is. If you take urban planning, you'll learn all about that. And that's a tool that cities have to keep really bad things from happening in one place without necessarily jeopardizing somebody's use of private property. Make sense? Hope so. That was the decision, Penn Central, that focused specifically on preservation and provided the powers for historic preservation to be able to control what they have. So as you see, what we're doing is developing the case for preserving historic resources and making that part of the city's mandate. And legislation was granted to the cities to establish these controls. But always the question of how far can you push that? And this is something that is not set in stone. All of this stuff, when you read about it, sounds like it's inevitable. In fact, it's not. And I will end up our discussion with talking about a court case, which is very much in everybody's eyes right now and relates to another court case here in Charleston. You can see we're building these legal measures to help kind of institute the preservation measures we've been talking about. The next case is St. Bartholomew's case. It dealt with religion. Essentially, the church was wanting to take one of their ancillary buildings and build a much larger building in order to provide money and profit for their larger mission, which they felt was justified. On the other hand, the large building immediately adjacent to the beautiful building that you see here was essentially going to take away from the character of it, and if not completely obliterate it. And so the decision was, well, the case was that the church wanted to do this as part of their mission. It was part of their, freedom of religion rights to do so, and that they couldn't, keep them from doing it. And the landscape ordinance said, preservation ordinance said, seriously, if you look at it, you're doing fine. This is really not necessary. And so that was kind of the controversy at the time. Even within the church itself, there were people in the congregation who were on both sides of the case. So it was quite controversial. So what basically happened is they decided that they really couldn't build it there. They lost the case, and this essentially established the precedent that religious organizations are subject to historic preservation ordinances as well. And they were not a violation of the First Amendment, which is freedom of religion. So here you have the whole sort of interplay of ideas that were going along. And you can see, once again, the courts are opening up the books and looking at it and trying to take a holistic view of it and see whether or not it is an actual problem for the church in order to keep their mission going. It's interesting. And so what we have is this case building one by one of the right for communities to establish preservation areas. Segueing from one church to another church, there was an interesting process here with the Unity Temple, which was a Frank Lloyd Wright case, of course, in Illinois. And in this particular case, both the parishioners and everybody were basically wanting to take usual preservation of this landmark to the next level and preserve the interiors and also the use of it in perpetuity. And of course, that required a different kind of view of it, where we were using something called easements. And of course, the establishment of the ability of preservation groups to use easements to help control the utilization and take it beyond the usual preservation concerns has been very important. For example, we use easements a lot. I've mentioned before facade easements here in Charleston to try to control or deal with the front of buildings to make sure we don't have air conditioners sticking out of the front or vinyl shutters being nailed up on the side and, stuff like that. We try to keep these easements as a tool, sometimes that take it to the next level to try to ensure the kind of material and continuity that we're looking for here. So what we have here is another, religious case, as it were. And so what this is doing essentially is taking us along the road here of the development of these kinds of ordinances, establishing the value of these historic preservation ordinances and the rights of local municipalities to, control this. Now, when we look at this stuff, it all sounds rather inevitable. It sounds like, well, it had to be. I mean, places like Charleston are wonderful. But the problem is that case law is constantly evolving. And so thinking about that, we need to look at kind of where we are now because it affects our abilities right now. The most recent court case dealt with this group called Kelo versus, I'm going to have to change screens here. So excuse me a minute while I do this. Kelo versus the City of New London, where they essentially looked at, I'm going to stop sharing for a second. Whoops. Stop sharing. And then go back to a different screen. Try to start sharing. Here we go. And we'll talk about this particular court case as kind of showing you just how these matters are not completely settled and that we're still working on them and that it's part of a larger conversation. Kelo versus the City of New London. Now, those of you who don't know it, Cato Institute essentially is a very conservative property rights organization and one that, took this case up pretty strongly to the Supreme Court. And although they lost, they haven't basically given up on the idea of private property, of course. Anyway, here we are. This is kind of an extreme example, but it points to where we are in the city too right now in terms of trying to find ways for preservationists to be constructive and not just, shall we say, dictatorial. Go ahead.
This is the so-called takings clause in the Fifth Amendment. It enshrines your right to private property without undue government interference. Traditionally, takings for public uses included highways, schools, and other government-owned and operated projects. But in 2005, the Supreme Court turned that notion of public use on its ear.
Economic development, the payment of higher taxes or the creation of more jobs is now a public use under the Fifth Amendment to the U.S. Constitution, a very dangerous precedent that the court set. But as I mentioned, that has led to this this backlash against what I think it's fair to call the most universally despised Supreme Court decision, perhaps in its history.
My name is Suzette Kelo, and the government stole my home.
Suzette Kelo is an American hero. She is a woman who stood up for her rights and in the process stood up for the rights of all Americans. She was a homeowner in New London, Connecticut, that simply wanted to keep something that was incredibly valuable to her, the first home that she ever owned.
For Suzette Kelo and her neighbors, that Supreme Court decision was a profound disappointment that capped an exhausting legal battle.
Over 10 years ago, I was lucky enough to find a great deal on a house with a terrific view of the Thames River, the Long Island Sound, and the Atlantic Ocean in New London, Connecticut. I spent every spare moment fixing it up and making it the kind of home I had always dreamed of. I'm sure you've heard the expression, location, location, location. Well, this was the wrong location, only I didn't know it yet.
Just after Suzette Kelo bought her little pink house in 1997, the Pfizer Corporation announced it would build a massive new research facility in Kelo's Fort Trumbull neighborhood. The city council approved plans in January of 2000 to help Pfizer acquire the land it wanted in New London. The plan made dramatic use of eminent domain and was all in accordance with state law.
The group that had the power, I think, also had some arrogance. And I think they understood that the law did, as the law was written in Connecticut, they did have the power to do what they were doing, as wrong as it seems. And as long as anybody was going to challenge them or fight them, they were going to enforce the law and exercise it no matter what. And I think the more the homeowners dug their heels in, the more the people with the power dug theirs in and said, well, we'll show you.
The homeowners who wanted to stay were served with eviction notices the day before Thanksgiving in 2000, but the legal battle between the Fort Trumbull residents and the city continued for 5 more years.
The Supreme Court has agreed to decide if governments can seize people's homes and businesses for economic development projects.
The High Court heard the case in 2005, and it was to be the most despised Supreme Court decision in many, many years.
What the Supreme Court basically said was our land was only our land until someone else could make better use of it and pay more taxes.
Justice Sandra Day O'Connor wrote in her dissent, the fallout from this decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations and development firms. Justice Clarence Thomas wrote in his dissent, something has gone seriously awry with this court's interpretation of the Constitution.
If there's anything that I think should take high priority in America, it is the protection of private property.
This is something every American and certainly every member of Congress can identify with.
Reaction to the 5-4 decision was immediate and forceful.
As a result of the Supreme Court's unbelievable ruling, a majority of the states have passed legislation offering more protection to American property owners.
They certainly felt the pressure of the public. I mean, a lot of legislators told me as I was talking to them and lobbying for this legislation throughout the country that they've never had phone calls like they did in reaction to any court decision, whether it's from the Supreme Court or any other court.
The reason this case became what it is today isn't because the Supreme Court said 5-4, you can do this. It's because how the general public across the United States reacted to that decision.
And though it may be a small consolation, the project that cost Suzette Kelo her home has essentially gone nowhere.
3 years later, Kelo's house has been torn down and the lot where it once stood is vacant. In fact, Real Clear Markets reports that there is no new construction in the area because the city-sponsored developer has been unable to secure financing because interest in the project is minimal.
There is absolutely no new construction in that area whatsoever.
And there's nothing there, nothing at all.
They haven't built a thing. They've knocked a lot of things down, but they haven't built anything. And as far as job creation, job stimulus, the only jobs that have been generated there have been for demolition crews.
There were 78 houses there, 78 tax-paying residents. Now there's nothing there. There's certainly no taxes.
There's likely to be no new development in that area anytime soon.
All it is now is a dust bowl, really. And I really hope they choke on the dust.
I think ultimately the Supreme Court will hear this issue, and I think they will reject Kelo. I think Kelo is one of those decisions, like Plessy versus Ferguson and Korematsu, the case that upheld the internment of Japanese citizens, is destined to be overturned. And I think it's only a matter of time before that happens.
So here we are, we're back. So I think you can see that we're dealing with case law, which is evolving. And in the case of Charleston, what we have is, several new court cases that are coming up that reflect on the ability of cities to continue doing as they have been doing. In this particular case of the Kelo versus the City of New London, there have been several counters to that coming from places like out west. I think it's an Oregon decision, basically counteracting that and trying to keep the power of the city sort of in check in that regard because it felt it was egregious. Around Charleston, we have similar situations, I guess, to some extent, where we have a lot of really heavily lawyered up development companies that are coming in and essentially trying to actually set their own development standards. Most recently, the beach company over at Sergeant Jasper over there by Colonial Lake came in and said, we want to develop more than the neighborhood wanted, more than anybody wanted, more than was approved by the BAR. And essentially they took them to court to say that, really the BAR was acting outside its bounds, that it's within their zoning rights to be able to do this, and that therefore they could not without its being a takings. And the decision really here locally was they didn't have enough money to fight the developers in this regard. And so what happened was they got what they wanted. Now, this is a case, as they refer to it in the textbook, as approvals through litigation, where they're able to do it with attorneys and with the threat of lawsuits and individual lawsuits, rather than with the statute. So what I'm pointing to is, although we have established case law, Berman versus Parker, all the way back to them and others, that provide a framework for historic preservation ordinances, as we move forward and as the city planning becomes more complicated, we're going to find that, you know, we're going to be dealing with developers who are their own power structure in and of themselves, who know how to play the game. We're also dealing with a greater concern from individual people and private property people to push back in some cases against the power of cities. So what does all this mean for preservationists? It probably means what it always has meant, and that is that we have to get together, we have to develop a consensus. We're primarily a group that is nested within communities and in trying to figure out how we build a community together. And so, although it may sound like preservationists are ruling the world in some cases, when you look at all this law, you realize that it's much more in flux, and it's much more something where we as preservationists have to take a proactive view and become part of a community and part of that whole process, rather than just assuming that we can get our way in every particular situation. So that's my take on it. So if I were to ask a question related to, on the final, say, related to case law, where I ask you to talk about the forces at play and how the individual court cases came out, you have some basis there. In fact, I've taken it beyond what the textbook says to mention the case in Charleston at the Sergeant Jasper. And so this is meant to be helpful and to supplement the text and the lecture. I'm open for questions or thoughts at this particular point. Everybody, I'm going to unmute you all so everybody can talk. They have mine too. Hello. Could you relate to any of this?
Before even talking about the subject, I've always thought that new building on Colonial Lake was an eyesore.
Right.
Hey. Oh,
most people in that area think so too. Sorry, somebody else is saying?
I'm talking to my daughter. Sorry.
Sorry. Okay. So yeah, maybe your daughter has something to say. Yeah, no, I mean, that's what people in the area have said. Of course, you've got a little bit of NIMBYism there, where people are worried about keeping residential qualities there, and it's complicated in that regard. Y'all know what NIMBY means, right?
No.
Nope.
Not in my backyard. So once the residential area is established, there may be another use that could go there that would be helpful to the city as a whole, but the people who live in that area, who consider that their backyard, see it as a detraction from their property values and fight it. So this is a common phenomenon, generally speaking, and one that developers like to characterize all of preservationists as being simply NIMBYites. So you'll see that. In urban planning now, there's a new group called YIMBYs, which basically you might guess is yes in my backyard, which is trying to encourage different uses and a more robust kind of economic and city life. So these are kind of some of the terms of the day that might be worth considering. So does anybody sympathize with either the City of New London or with Ms. Kelo in this? You see the point about getting higher taxes and how unfortunately it didn't work out to be anything at all, and how this has become a very controversial court case and one that people are pushing back against. So again, case law, it's kind of dry, but it's always evolving. And as we start to look at projects, even on our individual or local community level, has a bearing on how things happen. So that's a quick reference to the text. Next time I'll pick up the designation of historic properties and talk a little bit about that. I'll be trying to record these lectures and posting them online so you have them to review. But I've given you a really good exam question at this point and, pick it up from there. I know most of you are busy trying to finish your reports, and so I will leave it at this point unless there are other questions. Anybody want to bring something up or ask a question related to the report?
Yeah, what time is it due?
Well, I said today.